Hello to my professor and my classmates. If I'm speaking kind of fast, it's because my phone has a limited amount of time that I can put in a video. So let me get started. The first thing I want to do is explain the purposes of the opening statement. The opening statement is very important. This is the time for the defense attorney or the prosecution to present to the jury their testimony, their evidence, and everything else. There are people that feel that jurors pretty much make up their mind after the opening statement, which means that if you're a defense attorney or prosecutor, you'll want to be persuasive, concise, and most of all, keep the attorney of the jury. There are 4 components to an opening statement. According to Tandem, what you have to do is present a clear picture of the case, the major events, the participants' disputes, and contentions. Secondly, you want to arouse the interest of the jurors in the case and general theories so that they will want to hear your evidence. If jurors become bored or if they become antagonistic, they may become inattentive while you present your witnesses, and you don't want that. Build a rapport with the jurors. Speak to them like they're intelligent people. Speak to them like they're on your level, which most of them are. For the defense attorney, the opening statement presents the opportunity to alert jurors that there will be 2 sides to the case. So do not make up your mind as soon as you hear the prosecution. Now, what I will do is detail the order in which opening statements can occur. First, the prosecutor or defense attorney makes their introductory remarks. Secondly, the people involved in the trial, such as defendants, witnesses, key players, will also want to give, the defense attorney or the prosecutor will also want to give details on where the event took place, who was involved, and actual details about the event itself. The next thing is telling the juror about the dispute or the problem. According to Brooke, it is important to tell your story in an effective manner without engaging in objectionable argument. Next, you will have to tell the story from the client's point of view. This is basically presenting the facts to the jury, and you want to be persuasive when you're doing this. The defense attorney or prosecutor may want to bring up weaknesses in the case so that you will be seen as honest. You don't want to do that during the actual case. Do it in your opening statement, because if you do, they'll at least say, okay, this person is honest. They pointed out the weakness in their case. Now let's see what they're going to present to us. Lastly, you'll want to have a conclusion that ties your opening statement together, that reasserts everything that you stated prior to that. Okay. Provide an opinion on the significance of opening statements. In my opinion, I do believe opening statements can influence a jury to sway in your direction. I believe it can keep a jury attentive, but I do not think in all cases it will influence the final decision. I feel this way because there are other major components that play in a criminal trial, and these components can influence the outcome, such as witnesses, expert testimonies, even how you present yourself and your client. That can also do that. What I think would be an improvement to opening statements, I feel that opening statements should be used to only present the witnesses and the key facts. And I do believe that prosecutors should not be allowed to go first in every single case. I know they have the burden of proof that they have to prove. I know it's all on them. But I feel that they are able to persuade a juror a lot quicker and easier than a defense attorney, because one, they're working for the state, so people think that automatically because you're working for the state that you're telling the truth. And I've actually been in a courtroom and seen a judge tell a prosecutor, you're lying. Okay, now examine the notion of latitude given to the attorneys from the judge when they're arguing in their opening statements. Pretty much this is given to them because, like I said, the prosecutor is able to present first. So the judge basically wants to allow the defense attorney to lay out all the facts and basically try to persuade, in fact, give them a head start on persuading the jury. Now, do I feel it's right? Kind of, sort of, depends on how you're looking at it. Me, if I ever became a lawyer, it would be a defense attorney. So, of course, I'm going to say, yeah, I think that's the right thing to do. But when you look at it from an ethical perspective, it's not fair. It's not fair at all. There needs to be some system developed, to me, that where we can decide who goes first in a case. Because let's be real, the person who goes first, they have the upper hand. They have the upper hand. Well, I'm going to finish off this video now. It was really fast. I'm sorry. I had to get this all under 5 minutes. This is like my 30th time trying to record it. Well, I thank you all for listening. I hope that I explained everything to the best of my ability, and I'm wishing you all good luck. Thank you. Have a good and blessed day.